The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. This is the time set for oral argument in our cause number CV140328, Petrocelli versus Anderson. Counsel, we are recording today's proceedings, so when you step to the podium, please identify yourself and the client you represent. Each side will have 20 minutes for argument, and Mr. Meyer, as appellant's counsel, you're responsible for watching the clock and reserving any time for rebuttal that you might desire. We have read the briefs and we've conferenced the case prior to argument. So with those preliminaries out of the way, Mr. Meyer, you may proceed.
Thank you, Your Honors. My name is Kevin Meyer from the firm of Broning, Obrick, Woods & Wilson on behalf of Isabella Anderson, appearing through the appellate pro bono project. In order for the family court to make a substantial change in the child's life, not only the parent's life, but especially the child's life, the family court needs substantial evidence to do so. And because the family court based its decision to change the child's school on an allegation for which there is no substantial evidence, the family court abused its discretion, and this court should remand this matter for further proceedings. What's clear from the family court's ruling is that there was an allegation that the child in this case was suffering from speech problems. But there's absolutely no substantial evidence to justify that decision. What you have is a child who is bilingual, and a child who had been attending a school in Avondale in which there were weekend programs that included burnishing the Polish language. You also have allegations regarding the disputes between the parents that mother would speak Polish to her child at times. That's the evidence of the child's language. What you don't have is a speech pathologist or any kind of elementary or education trained person who says, I've evaluated the child, and the child is suffering from language development problems, and there may be other problems as well.
Look, counsel, you're focusing on the language issue, but I thought the change in circumstances the trial court found was increasing acrimony and the child's need to change preschools, I believe. Isn't that the basis of the court's ruling and not necessarily the language issue?
There obviously is acrimony between the parents. That's true. And the best interest determination that the court made preceded the legal custody determination between the parents. There was a concern that the parents couldn't get along and that father needed a greater role in the child's life. And the court accomplished that by granting father greater legal custody of the child and making father the ultimate decision maker with respect to decisions between the parenting decisions. But when you look at the parts of the ruling that actually address the school choice, the only justification really given is the child's speech problem.
Well, having looked at the transcript and examined the judge's minute entry, I'll grant you, I think the use of the word delayed was less than accurate. But when I look at the transcript and basically what the judge was saying, I think it is a fair reading that by using the word delay, he was speaking about that the child here is not learning English or speaking English as rapidly as possible. It's not that there is a developmental disability, but that there may well be just some delay in becoming, as a child, fluent in English. And I think that's borne out by the record and some of the exhibits. At least that's a fair reading. I might not necessarily agree with it, but that's what trial judges do.
I don't think father's self-serving statement in this case constitutes substantial evidence. When you also consider the fact that the actual educational report provided by the teacher does not seem to demonstrate any concern.
But what's wrong with Mr.
Petrocelli?
Thank you, Mr. Petrocelli's observations? He's a parent. he's entitled to observe his child and provide factual information. He's not, again, if we take it out of the realm of developmental disability, which might well require expert testimony, he's a parent. He's been observing this child for 4 years, is entitled to make some observations and testify. What's wrong with that?
I think the court did not properly consider the self-serving nature of this, the way it relates to the acrimony between the parents, because one of the instances that father cites of alleged alienation is the fact that mother speaks Polish to the child. I think it's also relevant that the court, that Dr. Waldman pointed out that, and he's the only court-appointed psychologist in this case, and the only one who actually might be able to provide a learned opinion on this. The father was the reason that he couldn't perform that evaluation. So father essentially blocks the method by which there could be some scientific evidence. Father has a self-interest in.
That's my point. I'm not.
Father
I think
also.
you and I are splitting off on different directions here. I don't think there is any evidence that there is a medical or psychological impediment or some type of developmental disability with this child. I don't think there's anything in the record. I think the court perhaps used a word a little bit imprecisely, but when I look at the evidence here, and the fact of the matter is everyone who testifies at trial can be called self-serving. We represent, when I was a lawyer and you're a lawyer, we represent clients. They all have their points of view. They're all self-serving. So,
I agree. The other point I guess I would mention is that father was not the primary custodial parent. I don't know if his observation is really the best in that case, but if the school teachers aren't calling for this change, or even noting that I mean, they describe Adam as being a bit reticent or shy initially, but I mean, his evaluation by the end of the term is really full marks, an engaging child, so there doesn't seem to be any kind of educational risk. And again, I'm not saying that it has to reach the standard of some sort of that the allegation has to be a sufficient standard of developmental or medical disability, but there still has to be some sort of credible evidence. And given the nature of these allegations and given the nature of the contention between the parents, I don't think that rises to the level of substantial evidence in this case. And
if we put aside for a moment the language issue, okay, the court made a finding of the increase in the acrimony, which is really regrettable for any child, but apparently that was the evidence, and explains in his minute entry that the lack of communication is now affecting the child's medical treatments. I mean, there's evidence about that, the dentist and the double sets of x-rays and that. So why isn't that adequate for a change in circumstances?
I think it is evidence for change in circumstances with respect to those issues.
Right.
And that's why I think, if you look at the minute entry that the court issued on page 7, when you go down to the legal decision-making section, that's where the court uses the best interest language. And so the court is recognizing that, and all the analysis prior on pages 5 and 6 is talking about the acrimony between the parents and the need for the parents to work together to communicate better, especially with decisions towards the child. Later on, you don't see that best interest language when it comes down talking about the school. The main concern later on about the school, if it's not just the speech language, is the amount of time that the child is driving. But the court didn't solve that problem. If the court's stated reason is to reduce the amount of time the child is driving, the court hasn't solved that problem. All it's done is shift the obligation of driving to the parent, to the mother, who not only has a reduced amount of visitation time because she's spent shuttling an hour back and forth from Avondale to North Scottsdale. But it also puts us in a situation where Adam is in a school where he has to have a considerable amount of daycare, and that's in the record as well. So you've taken the child from a situation where he's in a community school where the mother has access to the child, and Adam at least has access to one parent.
But the problem I'm having with that argument, as I'm having with some of the arguments you've raised, is it seems like you're asking us to reweigh the evidence. We weren't there. We didn't see the parties in front of us. And I read this minute entry, which is much more detailed and faithful to the statute than many we see, and I come away with the notion that you're asking us to second guess what the trial judge saw and heard.
Respectfully, I hope I'm not doing that, and I don't mean to do that. What I'm trying to say is that when the family court states a specific reason as to why it's doing that, and there is no evidence for that, then we can't rely on the fact that there was a best evidence or a best interest determination later on other specific issues and say that everything then is being done for the best interests, or that everything is being justified by that change. When the court says, I'm trying to reduce the amount of driving time for the child, and then issues a change that does not reduce the driving time for the child, I think that is an abuse of discretion. When the court is talking about access to parenting time, and the court is increasing the amount of time that the child is sitting in daycare without access to either parent, I think that is also an abuse of discretion, because there is no evidence for that decision then. Trying to move on briefly for a second. If there was any question prior to February 24th that the family court was wrong to impose a supersedious requirement on this situation, it is absolutely clear after this court's decision in City Center.
Well, it may be, but that issue really isn't properly before us because it wasn't timely pursued, is it?
I think this court can accept special action jurisdiction in this case.
But to what end? I mean, where does that get you?
It demonstrates the fact that you have a litigant who was trying to challenge the name change and who didn't have a chance to do that. And it leads into the next part, which is the name change. Again, you've reviewed the transcript. The name change comes up at the very end, after the idea that this has been rejected a couple different times. There wasn't a proper presentation of evidence, and there wasn't a proper presentation of argument. It's really kind of done as an afterthought. And we think that the ruling is wrong in two respects. One, it really places undue emphasis on the notion of heritage or a family history.
I know you read it that way, but I read it as this court struggling to offset this terrible acrimony between the parents and the effect it's having on their son, and trying to balance that in putting his best interest, not either parent's best interest, at the forefront. I read this as a very difficult decision that the judge struck a proper balance on, not looking at the mother's best interest, not looking at the father's best interest, but what will preserve this child's relationship and enhance his relationship with each parent. I think this is a real uphill battle for you, which gets back to what's the point of the supersedious bond argument.
I think by disregarding the mother's role and having her first as well is also a violation of the Arizona cases we've cited. This all could have been presented to the trial court in a reasonable manner with actual evidence and actual argument, but the way it came about was too late at the end, and then there was no opportunity to actually address this because we were not allowed to stay the ruling.
Let me ask you on the supersedious issue, given the Cityscape case, I mean, it is clear that the bond amount was not proper, so let's put that aside. The statute and the rule really are designed to deal when we have a money judgment, which, let's put that aside, because that's not what's going on. So where does the court then have power to stay its ruling when it kind of falls outside of the issue, falls outside of the statute and the rule?
Certainly. I couldn't instantly think of the analog in family rule. I think is maybe 87, but I think Rule 62 would give you that right under the rules of civil procedure. The court has the right to make those stays, and I think when you have a litigant who was trying very hard, pro se, to challenge these things, there were objections made. She did everything she could. There should have been a chance for her to have her day in court, in an appellate court, before the court made that ruling, so that there isn't this back and forth.
That I understand. But going back to the state, this is one of these unusual situations where I don't think the name change, the issue, has I mean, it's very valuable to the person. Don't get me, I mean no disrespect, but it's not something that we can say it has a dollar value.
Correct.
Right, so it doesn't have an economic value. So if the court wanted to stay its ruling, but wanted to ensure that, let's say the appeal was pursued with appropriately and it wasn't languished, and that there's some ad terrarum effect, what would it have done here? Could it have asked for some type of bonding? Or would it have been a bonding requirement or something else? I can't think of what the else would be, though. Would that have been appropriate? Something more modest, though, of course.
I think the court could have conditioned its stay in a manner as you're describing. I think it wouldn't have been appropriate under 7A or under the statute 2108. And I would also point out that the record will reveal that the transcript from that hearing will demonstrate that she offered a $500 bond.
I know that. I saw that.
So the court simply wouldn't consider that at all. So I would think that, especially in a case where someone is proceeding in form of propers, that you don't want to impose really any monetary thing, but if you do, it would need to be reasonable. But at least that was offered here, and that was rejected by this court.
Mm-hmm. Okay.
Unless there are further questions, I'd like to reserve my time.
Thank you. Ms. Best.
Your Honors, may it please the Court, my name is Cynthia Best, this is Robbie Hendricks, and my client is Martin Petruccelli. I know it's been a very long time since I was in law school, but I remember one thing very, very
You're
vividly.
not that old. I don't buy that.
Excuse me?
I don't buy that argument. You're not that old. I'm sorry.
I actually am.
Okay.
But one thing I do truly remember is something that Judge Howe just reminded me of, and that is if you let me name the issue, I win every time. The issue of this entire case is not what Mother has written in her brief, all about the speech delay. If we just take that out of the picture, the trial court went through great pains to go through the analysis, and I do agree with Judge Downey, where he does a much better job than a lot of trial courts do, because he paid a lot of attention to the evidence. He was there for some of the preliminary hearings, and he read through the record, and he read Judge Kiley's transcript as well. So when he said and he wrote that there was acrimony, he was talking about a whole host of issues and problems and evidence and testimony and reports that had come through him and finally culminated in the trial that resulted in this minute entry. And so it wasn't just about speech. And when Mother admits that the acrimony was true, I think that settles the issue. Because there was this extreme acrimony, and I think the judge talks about other things as well in his minute entry on page 3, he talked about it's long existed, it's now become worse in degree, and now it affects the child's medical situation and medical history. So there is a substantial change in circumstances. And remember how this whole one of the issues in this case, Mom actually filed and pled and verified there was a change in circumstances. So it's hardly appropriate to come in front of the Court of Appeals and now say there wasn't one, because that is one of the reasons how we got to the trial court, and that was actually her argument to the trial court, was there was a change of circumstances. And she talked about the dentist, and I think that's one of the medical reasons that the judge talked about. So he actually agreed with Mother at the trial court level, and I just don't think it's appropriate for them to now say there wasn't a change of circumstances. I think the trial court did a really great job in talking about that first before he got to the actual best interest factors, and then he covered those one by one by one. He didn't limit it to a speech delay. He didn't talk about miles, other than they live 50 miles apart. He didn't talk about, and if our math is correct in our brief, then actually it is less miles, but I don't want to argue math. But he painstakingly went through each and every one of these best interest factors. And the one best interest factor that ties into the name change was, if you look at the complete totality of the record, Mom's acrimony, and I guess it's acrimony between them, has attempted to paint Father out of the picture, marginalize his ability to parent his son. And the trial court felt that, understood that, and did not think that was appropriate. And so when you really look at the balance that the judge was maybe weighing, if you have Adam living with Father as the primary residential parent, then the judge could sit and think, well, if I let Adam live with Father, the child's going to have two parents, because Father's going to include Mother in his life. If I have the child live with Mother primarily, it's going to be a constant battle, as evidenced by 4 years of litigation, and he's going to have Father continue to be marginalized. So by allowing Adam to live primarily with Father, Adam has two parents. If the judge had left Adam with Mother with the 60% of parenting time, he would have only had one. So I think it is in Adam's best interest, and when we look at this, and I think you've already commented that it's in Adam's best interest for these decisions to be upheld. that ties into the whole name change. If the child has both parents' names, and I mean, flip a coin whichever direction it goes, if the child has both people's names, both parents' names, then he does have a strong identity. And it was kind of one of these things where if you're going to change his name, it would be a perfect time to do it. I think that it is in Adam's best interest to have both names. Petruccelli Anderson is not an burdensome name for a child, and I think that the court painstakingly, again, followed the exact letter of the law, and in that paragraph where Judge Corey wrote about it, he went through each and every one of those factors that the case law required him to do. And I think that he did a successful job with that. So if you stick to the issues and you look at the material change, we check that off, that was met, then we go to the best interest factors. I think the judge did an excellent job in talking about Adam and Adam's best interest as you go through all of those, segues into the name change. And I don't have very much to talk about the bond other than it wasn't timely pursued. I'm focused.
There had been, or let's assume that we disagree. Okay. What should have happened here?
I think maybe set a lower amount. I think that when the statute says it doesn't apply in custody matters, that perhaps a name change is not like a custody, because if you file a bond in a custody matter, the parenting time continues. Well, here she wanted some action to happen, and you kind of have to have some vested interest in a stay. You can't just ask for it without anything happening. So maybe a minimal amount would have made her sort of have an investment in the stay itself. But to ask for the action with no input from you, requiring the court to do something, doesn't make perfect sense either. So perhaps a little bit of money in the game would have made it realistic to the person asking the court to make the stay.
Going back to the first part of your argument, let's assume for the sake of argument that we were to agree with Mr. Meyer that there's just nothing in the record to support that Adam has language delays or deficiencies of concern. How, in your view, if at all, does that affect the underpinnings of the court's decisions?
I think it would affect it greatly, Your Honor, if that was the only thing that he relied on, but he didn't. So if let's just throw that out if we're going to have a discussion about it that's going to drag everything down, because the acrimony is the biggest issue. And I think the acrimony kind of carries the day, and the acrimony is undisputed, which is the nice thing, because I'm not here having to argue that. I'm here to remind you that the other side agrees with us. And so if there is the acrimony as the huge umbrella, look at all the stuff that's under that. It's the CPS investigation. It's the denying of the parenting time during the holidays. It's the not returning the emails. When father would call and do Skype calls, she'd point it at the couch or point it at the wall. She would say to him in Polish, go find a toy right before dad calls. That acrimony, you could go through issue after issue and list after list. And, Your Honor, incorporated by reference our pretrial statement, a page and a half of all the things that we listed, and the judge actually found that mother misled the court and caused the litigation to be increased. She wouldn't show up for her deposition. She wouldn't show up for Dr. Cristiano's evaluation.
So your point is, even if there were no issue of speech delays, the record amply supports both changed circumstances and the best interest analysis?
That would be the much better succinct way to answer that question. Yes, Your Honor, I do think so. And remember, it also talked about affecting the child's medical treatments, and that's something that mother also pled. So I think the acrimony and the medical treatments put together, it covers a whole host of subjects and evidence and testimony. So I do ask that the Court of Appeals sustain the trial court findings that it's in Adam's best interest to have primary physical custody with his father and remain with his father and have his name changed, stay as Petruccelli Anderson. Thank you, Your Honors.
Rebuttal, Mr. Mayor?
Many children have parents who don't get along. They don't all have to move schools. There was acrimony. There were changed circumstances. There needed to be changed. We're not on appeal challenging the change in legal custody or the increase in Mr. Petruccelli's general parenting decision-making. We understand that happened. We chose not to appeal that. What we're saying is that a determination that circumstances have changed and a determination that best interests require changes, I think need to be specific, and they don't cover everything. In this case, we haven't said that there is, we haven't said that there weren't substantial changes. We haven't said that there wasn't a best interest determination. We're saying that when the court made a specific finding as to why it was doing what it was doing, it needed to have substantial evidence for that. The court didn't say, I need to change schools because Adam needs to be closer to his father because of this acrimony. And so what the court did is it said, instead I'm going to say that he's not, his language skills are retarded or are not progressing as well as they should, and therefore I'm going to move him. And even though I've talked about concerns about driving distances, even though I've talked about concerns about Adam having access to his parents, and even though mother's situation is a situation in which he's in a community school, he has friends, there are activities, and there is at least another parent around where he doesn't have to be subject to additional time in daycare where he's alone and has no parent.
But, the court knew all of that, and I guess I agree to some extent with Ms. Best, and I also understand you weren't the trial counsel, and you've done a great job in litigating on appeal the issues that are at least colorable. But the trial court had all of that in front of it. It weighed it, and it was clearly bothered, as I think every judge up here is, by these parents' treatment of each other and dragging their child into the middle of their acrimony, which is inexcusable. And that permeates the decision, and so something had to change. And yes, maybe the court made a couple of statements that aren't as strong as others, but again, I get back to the point that you want us to reweigh everything, and the acrimony and the effect on the child, to me, was the beginning and end of the child's best interest in the changed circumstances. I mean, it's inexcusable.
And I think the court addressed that by making sure that there was greater control for the father and greater input in the decision-making and finally making him the final determination. I don't think we need to then make a wholesale change in the child's life, or at least if we're going to, I think there needs to be a specific statement by the court that in addition to that, I think we need to have I think we need to have Adam closer to father so that he has more time. Of course, it doesn't really help because father isn't available to get him on a preschool schedule. He has to be in daycare. So I think the court has to be held to the reasons it states, and there has to be evidence for those things. We can't just have every change happen as a sort of punishment for the parent's character. The court addressed that properly.
It's not punishment for the parent's character. It's not even punishment. It is the parent's actions in forgetting the child's best interest and putting their own pettiness in front of the child's best interest.
And I think there are ways in which that could be addressed, but because there was no evidence that there was really anything wrong with the school he was at, other than father's statements, again, that relates to this alienation concern, the court should have been more hesitant and should have had evidence that there needed to be a change in the school before the court shipped the child across the valley and put him in a new situation.
Judge Downey raised a very good point. Having looked at the transcript and read carefully the court's minute entry, the evidence of acrimony and the effect that had was, at least as I read this, front and center in the judge's reasoning here. And that the school was, and changing the school was really a way to try and address the fundamental problem here, which had to do with the conduct of the parents towards each other that was affecting the child. And it just seems to me the school is, to use not a very good analogy, the school is the tail on the dog. The dog here is the acrimony.
I think the best way to have addressed the acrimony is the way that the court did, which is to talk about the parenting decision-making authority and to address those decisions. And the court specifically identified that it was making that change based on the best interest of the child.
So taking your argument, what should the court have done here? What would you have changed from this order?
We would have, the part that we would like remanded is simply the determination of school, and then I guess parenting time as it relates to transportation.
Wouldn't that be put us right back in the saddle of some of the issues that gave rise to all the acrimony? I mean, or that the acrimony affected, I think to put it that way, that the acrimony affected all these issues.
I can see that that might be a possibility on a rehearing, but I think, again, we have to take the family court at its word. And if it's stated reasons, if it gives a stated reason and the other reason that is being used to justify it is absent, I think that's an abuse of discretion in that case. The way that the court stated this, There may have been other considerations in its mind, but when it came time to put this down on paper, the court said there's a speech problem and I need to fix this. There was no evidence of that. Thank you.
Thank you.
Thank you.
Thank you both for your presentations. We will take this matter under advisement and issue a ruling in due course. At this time, the court stands adjourned. Thank you.